By now, you're well familiar with the idea of the culpability spectrum. It ranges from intent through negligence and to strict liability, which is a zero fault state. We've mapped a number of points along this culpability spectrum, from double duty intent, which is a hard proof, to knowledge with substantial certainty, which cuts the corners on intent a little bit. We've talked about recklessness, which lies between intent and negligence, the concept of unreasonableness, which is at the heart of negligence, and then the zero fault state of strict liability. Moral culpability is different from legal culpability, so it's almost never necessary for a plaintiff to show that a defendant was evil or malicious in order for the plaintiff to win the case, though evil or maliciousness can be evidence of legal culpability. It does happen, though, that moral culpability often coincides with the culpability spectrum. So a defendant who is evil or malicious very likely can be proved to have borne double duty intent, that is, to have intended the negative or evil result that pertained to the plaintiff. At the same time, a defendant who is responsible in strict liability might be a perfectly good company or a perfectly good defendant and have no moral culpability at all. We can see a correlation between the culpability spectrum and the kinds of damages we've seen in the pound progression. So when we had physical injury, such as in Garrett v. Daly, we saw the court allow a little bit of corner cutting on intent and letting knowledge with substantial certainty stand in instead. When fraud allows liability predicated only on economic loss, the proof goes a little bit higher than intent, requiring that the defendant intended the plaintiff to rely on the misrepresentation. The proof doesn't go quite as far as double duty intent, because the plaintiff in fraud does not have to show that the defendant intended economic loss to result. But where emotional distress is concerned, arguably a pound step 3 tort, the requisite proof is double duty intent. The plaintiff does have to show that the defendant intended the plaintiff to suffer specifically the harm of severe emotional distress, the hardest proof. This correlation shows us that the culpability spectrum is being used to compensate for movement down the pound progression. So when we have high confidence that an injury has occurred and that we can evaluate it, as in the case of physical harm and battery, we're willing to cut a little bit of a corner on the culpability expectation that the plaintiff has to prove. But when the plaintiff is claiming only emotional distress, we worry about problems such as plaintiff perpetrating a fraud on the court, or whether our verdict will be fair and just, and so we increase the burden on the plaintiff to prove something more, double duty intent. That gives us a higher confidence that we're reaching a just and fair result, and that the case warrants the intervention of the judicial system in people's lives.